My name is Christina Voigt. I'm a professor of law at the University of Oslo, and I am here as the legal counsel for the International Union for the Conservation of Nature, which was a part in these proceedings. IUCN is an international organization, so we represented 144 states and 1,400 NGOs in these proceedings. Well, it's a historic day, right? It's a really interesting development that the International Tribunal Law of the Sea received the request for the advisory opinion, actually rendered the opinion that we heard today. I think the tribunal did as well as it could. It really delivered its opinion within the possible legal space that it had. It's a well-founded opinion based on science, based on international law that informs the United Nations Convention on Law of the Sea. So I think what we've seen today is a very important legal development in clarifying states' obligation to protect the marine environment against the impact of climate change. They clarify what the state's obligations are, right? Even though they are themselves not legally binding, they give an authoritative statement of what those obligations actually are. And states, well, we're working in a gray zone, right? The United Nations Convention on Law of the Sea has never been interpreted in the context of climate change. So it was unclear to what extent greenhouse gas emissions qualify as pollution, what are states' obligations if it is pollution. And now we have clarity, and states have clarity, and I think that's really important for domestic legislative processes. We also heard very many references to the Paris Agreement, so there are processes ongoing to, for example, currently to prepare the next NDC, which is supposed to be communicated next year. So all these processes play together, but they're also important, I think, for domestic judges in ongoing climate litigation cases in domestic courts. I think the advisory opinions, despite not being legally binding, will inform what domestic judges will find in those ongoing climate cases. Yeah, I mean, this is a building on a stepping stone, right? We have currently 3 parallel advisory proceedings at the International Tribunal of the Law of the Sea, and then the ICJ, but also the Inter-American Court on Human Rights. And it is expected that the ICJ, as the highest judicial organ of the United Nations, will deliver its advisory opinion as the last one. So it probably will wait for the other 2 courts to render their opinions. And I'm very positive that the judges in The Hague will be very well listening, especially to this tribunal, but most likely also to the Inter-American Court, in clarifying bits and pieces of the bigger question that's put to the ICJ. But the ICJ also has to say something about the law of the sea and what is an UNCLOS to protect the climate system. So I think the ICJ will study very clearly and diligently the advisory opinion from Hamburg today. Yeah, well, what do I wish? I think to really clarify the substantive legal obligations. So what do states have to do to address climate change? Because we do have the Paris Agreement, which contains primarily procedural obligations, so states have to put forward their NDCs, which are climate plans. They have to be at the level of their highest possible ambition, but the Paris Agreement doesn't really answer in any detail what is it that states have to do. And I think clarification from these different international courts and tribunals on the material, the substantive obligations of states, I think that would be really helpful, because this is what eventually matters, right? It's not just the document you send to the UN, but what you actually do at home to reduce your greenhouse gas emissions to net zero and below.
Okay, thank you. That were all the questions I had.
Okay, thank you so much. Thanks.